Just because you had prior incompetent morons like Mayorkas and Biden not doing anything doesn't mean that Trump can't do anything to enforce the law. Whatever you wish for me to take from it, she says, it's not a direct response, nor is the quip about smuggling someone into the U.S. This judge is not happy with him. Maybe she'll hold him in contempt.
Jesse, you know, when you're listening to all these liberal reporters, they keep calling him a Maryland man. He's not a Maryland man. He's part of a foreign terrorist organization. He's a member of MS-13.
An Obama judge is not happy with Trump and the DOJ and Homeland Security. This is the case of Kilmar. And we're going to read through this declaration. And there's something very interesting here. This was submitted by Trump to the court. And inside the declaration that was submitted today, the date of this recording, what we're going to see is that the DOJ from Trump is saying something like, we are prepared to facilitate Abrego Garcia's presence in the United States. What? They're going to facilitate his presence in the United States? What exactly does that mean? Well, ultimately, we'll take him in to throw him back out, but we'll come back to that. But the hearing took place today, and remember, this case is in the courtroom of Judge Paula Zenas. This judge, appointed by Barack Obama, political appointee. This is the case involving Kilmar, who is, according to a judge, somebody connected to MS-13, was found to be non-bondable in the proceedings. Here, you saw this back from 2019. This immigration judge, Elizabeth Kessler, said he is not bondable because of his connections to a gang, and he appealed this, of course, and was denied the appeal. So this guy got plenty of due process. He's not in the country legally, never had proper asylum here, and the entire narrative has been poisoned with a poison pill. DOJ attorney who was later suspended, calling it an administrative error. But this was never an administrative error. Once people who are in MS-13 or adjudicated to be MS-13 were declared to be foreign terrorists, all the rules changed. And under the U.S. Code, the Attorney General has the power under the law to have removal of an alien to a country if the Attorney General decides that the alien's life or freedom, right, can't move them to a certain place if they're going to be injured. But there's an exception. If the Attorney General decides that in subsection 4 here under U.S. Code, there are reasonable grounds to believe that the alien is a danger to the security of the United States, well, then under that provision of the law, the Attorney General decides, not a District of Maryland federal judge. So that is under the law. 8 U.S. Code 1231. The judge can look it up. But the point is, the Alien Enemies Act and the declaration by the Attorney General, Trump, Homeland, and others saying that this guy is now a terrorist changed his status and made him removable. So it wasn't an administrative error. And we've talked about that many times before. Now, they came in the form of the following. And what we can see is that this was submitted yesterday at the conclusion of the day. And they say it was late and their judge is going to, not be happy about any of that. But here's what they said yesterday. It says, look, I am Joseph N. Mazzara. I'm acting general counsel of Homeland Security. I'm the lawyer for Homeland. Now, I provide this declaration based on my personal knowledge. Now, I'm aware that in the instant lawsuit that's been filed about Kilmar is occurring. Now, on March 15th, writes the lawyer for Homeland, Abrego Garcia Kilmar, a native and a citizen of El Salvador, was removed to El Salvador pursuant to Title 8 of the U.S. Code. See the declaration of Evan Katz we read yesterday. Now, during bond proceedings in 2019, an immigration judge, just showed you that document too, upheld DHS's decision not to grant bond, finding that Homeland's determination that he was a member of MS-13 was trustworthy and supported by other evidence. And so a judge found evidence that was good enough for the judge. Noted that Abrego Kilmar failed to present evidence to rebut that assertion, right? They even gave us the quote. Thank you for the assist. Now, the Board of Immigration Appeals, a second proceeding, upheld the finding when he appealed. Oh, we got that document too. 2 reviews by independent bodies in a judicial setting and format, which is due process. The guy got due process. He had 2 hearings, one of them an appeal. He gets more due process here than many people get when you're even fighting a traffic ticket. Most people don't even fight him or appeal him, right? And this guy didn't show up to court for traffic tickets. Abrego was ordered removed by an immigration judge. So all those people who say bring him home, he already had an order of removal. He was also granted withholding of removal by an immigration judge, which at the time MS-13 was not declared a terrorist organization and not part of that consideration. And now, as we see under 8 U.S. Code, what I just shared with you, the Attorney General under the declaration, under the proclamation, can say this guy is a danger, and under the law, he's no longer eligible for withholding. Saying Abrego Garcia, though, is no longer eligible for withholding because of his membership in MS-13, which is now a designated foreign terrorist organization. The administration changed. Just because you had prior incompetent morons like Mayorkas and Biden not doing anything doesn't mean mean that Trump can't do anything to enforce the law. DHS has established processes, they write to Judge Zenas, for taking steps to remove domestic obstacles that would otherwise prevent an alien from lawfully entering the United States. Now, Homeland does not have authority to forcibly extract an alien from the domestic custody of foreign sovereign nations. The judge wants them to go pull a Mission Impossible with Ethan Hunt and zip line down, pull him out of the prison cell, bring him back. So here's what the lawyer says. Now, I am aware that the president of El Salvador, Bukele, was in Washington yesterday to meet with Trump. They held a bilateral summit, and I understand that in response to a question about Kilmar, Bukele said to the Caitlin Collins person, well, I hope you're not suggesting that I smuggle a terrorist into the United States, are you? How can I smuggle a terrorist into the United States? Of course I'm not going to do it. The question is preposterous. And the video of the meeting is on YouTube. We played it here. Amazing. So I declare under penalty of perjury, this is true. And obviously that's their citizen. It's their country. They know as much as we know about the dude. He came from there. So he's saying, I'm not going to release a terrorist either. Then we got an update from today. They sent this in. Same guy, Joseph Mazzara, coming in the Kilmar case, says, all right, look, on March 15th, copy and pasting, saying Abrego was removed to El Salvador. And during bond proceedings in 2019, an immigration judge said the following, copy and paste it again. Trustworthy, DHS, and supported by other evidence, MS-13, and noted that he did not rebut it at the time. So the Board of Immigration and Appeals upheld it, and then he was ordered removed. So he was also granted withholding, but he's no longer eligible for withholding because MS-13 is designated as a foreign terrorist organization. All the same, copy and pasted. Now, Abrego Garcia is being held in the sovereign domestic custody of the independent nation of El Salvador. Homeland does not have authority to forcibly extract him from there. But DHS has established processes for taking steps to remove domestic obstacles, this is the facilitation, that would otherwise prevent an alien from lawfully entering the United States. That's curious. We do have a system for this. And so this lawyer, general counsel, I have been authorized to represent to you, Judge, that Homeland is prepared to facilitate Abrego Garcia's presence in the United States in accordance with those processes if he presents at a port of entry. Wow. You're asking yourself, what? They're going to help him come back here? They're going to facilitate his return? That's crazy. We're going to negotiate with an MS-13 member to come back into our country? Well, let's not get ahead of ourselves. What does facilitate mean exactly? Well, I have been authorized to represent that if Kilmar Abrego does present at a port of entry, so if El Salvador on their own volition and own authority via President Bukele, if they release him and Kilmar does present at a port of entry, he would become subject to detention by DHS. Now, in that case, Homeland would then take him into custody in the United States and either remove him to a third country or terminate his withholding of removal because of his membership of MS-13, a designated foreign terrorist organization, and we would then remove him to El Salvador, which is what we've already done. Now, they should just say again right there because that's what they did. So he says, I am now signing this under penalty of perjury, saying I'm aware that the president of El Salvador was in Washington and they held a bilateral summit. What I understand to be the unofficial transcript of the meeting is here. This is what I've got for you. If you want to read the full transcript of the meeting, you can check it out at rev.com. Signed by Joseph Mazzara. Now, the ACLU, they had a fit over this. As you can see, they sent this one in. They said, oh my gosh, Your Honor, how dare they? We want him released immediately. They write, the government contends, these are the gangbang lawyers, that the term facilitate is limited to removing any domestic obstacles that would otherwise impede the alien's ability to return. But that's not so. The Supreme Court ordered the government, you can see here, to facilitate Abrego, they quote it, release from custody in El Salvador, and to ensure that his case is handled as it would have been had he not been properly sent to El Salvador. Now, that order is rendered null if construed only to require removing domestic obstacles. So to give any meaning to the Supreme Court's order, the government should be at least required to request. All right. So this shows you that they know this has no teeth and this argument is crap. Like, look, if you think that that is the order of the Supreme Court, honestly, if you think that the order is from the Supreme Court, release from custody to ensure the case is handled as it would have been had he not been improperly sent over there, well, then you better, send some tanks down there, right, to get this done. Like, they ordered you to get it out. So now they're admitting in this, well, at least just have him ask. Can they just ask? Like, just have him write a letter and send it over. Now, contrary to the government's assertion that it lacks authority to take any such actions, its own ICE policy directive requires DHS supervisors to coordinate to facilitate the return of removed individuals. Does it say remove terrorists too in there? Does it also say in this statute here, this directive, which we don't give a crap about, these directives, we care about the statutes and the law. Remember, it goes to U.S. code, then it goes into Code of Federal Regulations that pervert the U.S. code. Then from there, it goes into directives and memos and all these things, and it perverts everything. So they cite stuff that is useful to them. The return of removed individuals. Well, guess what? He's not just a removed individual. He's an alien enemy declared a terrorist of a terroristic gang. So thank you for your irrelevant statute. It's not in your Venn diagram anymore, okay, Kamala? We moved it out. It's over here now. Now saying the Secretary of State Rubio, this is the ACLU lawyers writing, they announced that the government delivered an additional 10 detainees to El Salvador on Saturday. Amazing. They just keep going. There are no brakes on this train. Now, that involved all three of the actions that the government says that the courts can't order, which is making demands of El Salvador, dispatching personnel, and sending aircraft. So they're like, well, if you're sending them down there already, just pick them up, put them on the plane. You're already stopping by. Like, can't you just pick them up? You're on the way there anyways. Just drop them off. Says the government holds contractual rights to send prisoners to its contract facility where the U.S. has outsourced its prisoners. And so it can exercise those same contractual rights to request their relief. Now, since this court order, the government is not giving updates. The government's updates do not indicate that any steps have been taken to comply with this court's orders, and there is no evidence that anyone has requested the release of Abrego, because they haven't. That's why there's no evidence. No one's requesting his release. Nobody wants him out. So this all got signed off on here by Jonathan, Cooper, Quinn, and others, Murray. And this looks like it's a different law firm here. So I'm not sure if these are the ACLU gangbang lawyers or not, but they're certainly joining in on the fun. So we got a lot of them. Now, here is what also happened with this in the District of Colorado. Same type of situation. So it's about the proclamation and the immediate removal. Colorado, we're free. We need an emergency order ordering that Trump shall not remove these people from our country. We seek a class action on behalf of all non-citizens in custody of Colorado who are subject to the Alien Enemies Act, okay? The deportations will continue until the country improves. Now, the class is identical to another case, which was in the Southern District of New York, and we've got incredible reports that as recently as this morning, Venezuelan men at the Denver Contract Detention Facility who had been accused of being Tren de Aragua gangbangers instead of the MS-13s were rousted from bed and told that they were going to be leaving the detention facility today. Going home, back to Venezuela. They repeatedly asked where they would be taken. I said, home. You don't need to know. You're getting out of here. Bye. They were subsequently informed that the flight that they were supposed to be on had been canceled today, and therefore, upon information and belief, they have not been removed from Colorado. So given the likelihood, however, that without further clarity from the court that they're going to be removed, we request an order, keep these Tren de Aragua gangbangers here. The ACLU lawyers want them badly. And second, we want clarification as to the length of the order. We want it to last a long time. Don't get them out of our country. Okay, so this is happening. They're filing these lawsuits in multiple jurisdictions everywhere. And it's just wild to see the ACLU work so hard for illegals. They didn't fight for Americans as far as I remember when our government was locking people down or firing citizens during COVID, or when they were abusing people who were fighting for pro-life causes, or when they were abusing the J6ers, or where was the ACLU when they were running roughshod over the entire Constitution when they were prosecuting Trump? Nowhere to be found. But soon as the gangbangers are in trouble, and the Trans de Aragua, as we have called them, because I think one of the gangbangers was trans, as they said, and was going to be attacked if he goes back home, they go wild. So they were out there today. This is the crowd that they drew out there protesting outside of Paula Zenas's hearing. She was holding that today. We're coming into that. Here's what it sounded like. Okay, so they're not even speaking English. It's just screaming in Spanish. Cuando, ahora, when, now, when. Now it's like you got to even come up with a better chant. So upside down flag, bunch of terror-loving morons who don't know the difference between, I guess, a citizen and a non-citizen, or understand the difference between withholding of removal and an order of removal, which are different things, and how the law interfaces. But that's what they look and sound like out there. Don't even know what they're protesting for, but they were there. Now, inside the courtroom. We got some details. Roger Parloff reporting for us what happened inside the Maryland courtroom. There are protesters out there screaming, "Bring gangbangers back to America. Cuando ahora? Cuando ahora?" Okay, Roger says, now I asked a court clerk how we pronounce her name, Paul Zenas, and her last name. She calls it C-knees, pointing to her eyes and to her knees. Don't call her Zenas. She hates that because it sounds like penis, and I bet she hates it. So while you were waiting, there's another Lawfare article. We've covered it, a lot of what's inside. We got the status report, and suddenly Judge Paula Zenas is on the bench. All rise, please be seated. She says, all right, everybody. Appearances, please. Good morning, Your Honor. Drew Ensign and Ernesto Molino for the Trump DOJ. Nice to be here. Good morning, Your Honor. Rena Gandhi for Abrego Garcia. And there's a bunch of other clients in the courtroom as well. The judge says, well, we're going to get started today with what the plaintiffs' ACLU Kilmar lawyers have filed. They're asking for additional relief. We just read through the filing. They say they want to request, make him request his release. Make him say, just ask. ACLU or Abrego Garcia lawyers say, well, Your Honor, the reason we're asking for this is because the Supreme Court ruled that the government is properly required to facilitate his release from custody in El Salvador. The release. And to date, Your Honor, they provided no evidence of what, if anything, the government has done to facilitate his return to America. Now, they have not even unambiguously requested his return. And there's no evidence that if the government has exercised its contractual right to obtain his return either. So they're not even asking, and they have a contract, so they could just cancel the contract and make him come back. The government does this all the time. And this doesn't interfere with foreign policy at all. It's just contracts. We've seen it time and time again. And so under the rules, Your Honor, we want a deposition of Trump and all of these Homeland and DOJ people who have fuera these people. Under Rule 30b-6, we want a deposition. And so we would ask you to direct the government to submit to a deposition. Whoa, judge says, wait a minute. Government says, all right, government lawyer. Well, you would not be opposed to interrogatories, would you? Like if they ask you some questions, government, would you be opposed to that? No, Your Honor, we would not. Judge says, well, your motion, Kilmar lawyers, also asked for broader relief. You're also asking, maybe this is a new filing that we haven't seen yet, which would be contempt, broader relief, like contempt. Sounds like you're right sizing it. From my perspective, right, Mr. Abrego Garcia has already won his injunctive relief. So you came into my courtroom, in other words, asking for an injunction to bring him back, and you won that. Now you're asking for more. Now you're asking for contempt. Is that right? Well, Your Honor, every day that he's retained in CCOT in El Salvador is another day of irreparable harm. And the judge says it's not for this court to engage in the process. We have to give both sides process, but we're going to move. And the judge says there's not going to be any tolerance for gamesmanship or any grandstanding in here. And so this process, Kilmar lawyers, sounds like expedited discovery. Is that what you want? Is that the core of what you're asking for right now, right? It sounds like she probably says, yes, that's what we want, discovery. Judge turns over to the government. Drew Ensign, Trump lawyer. Mr. Ensign, now let's take off table a hearing today. I know we're here, but let's take that off. Now, I'm not going to issue a show cause today for contempt findings. That's not going to happen today, but I do find it well within my authority to proceed with expedited discovery. And I'm going to determine whether you are abiding by my court orders, whether you intend to. And if not, my question for you is it in bad faith? Is it in good faith? But let's get to the bottom of it. Do you have any problem with that? Your Honor, as we just filed recently, we're prepared to facilitate his return to the U.S. under the meaning of the word facilitate. Okay, so judge is like screaming at him about all this stuff. Like, you're going to do interrogatories and all that. He just kind of parries that. Says, Your Honor, look, don't need to get into all of that. We've already explained. We're prepared to facilitate his return to the U.S. under the meaning of facilitate that the INS uses. Judge says, well, let's talk about that. You know, first you say my order is inconsistent with the Supreme Court. Now I reject that. She reads from the SCOTUS ruling. She says they even said right here, okay, the order was totally a mess, which is why their side is declaring victory. Trump's side is declaring victory because it says nothing. It can say whatever you want it to because it's idiotic. But the judge pulls it up. It says here, be prepared to share what it can. And they're like, well, that's right. And we are. This is what we can share with you. We're doing what they said. You say that facilitate should be limited to domestic obstacles, but you don't cite any law there. Well, we cite from the INS manual, Your Honor. That's where it came from. But you don't cite to one authority for your definition of facilitate. What does that even mean? You're only referring to domestic obstacles. Is that fair? That's fair, right? No, Your Honor, I don't believe so. I cite the ICE policy directive. In fact, it's a term of art in the immigration context. Like, that's probably why they used it. Well, I need evidence in this regard. To date, what the record shows is that nothing has been done. I've asked for daily reports and I've gotten very little info of any value. Your Honor, there have been significant steps. It was raised at the highest levels yesterday in office. Trump had a meeting with Bukele. They were there. It was hilarious. Judge says, well, the Trump people have never responded to the question. What steps have you taken? Why don't the defendants just ask, she asks. Will you release him? Just ask. Well, Judge, because we don't want him released. Neither does El Salvador. That's why. She says, what happened at the Oval Office is not before the court. And my order was a very simple directive. It is only asking for things that the Supreme Court said I'm entitled to. Now, I don't consider what happened yesterday at the Oval Office as any evidence before this court. Trump's attorney, Drew, says, Your Honor, the issue specifically was raised yesterday. What are you talking about? With the highest authority in El Salvador, the president was here. We got his position. His position was, we're not fond of releasing terrorists. You heard it from the man himself, so what are you yelling at us for? Judge says, well, that's a non-responsive answer, Bukele. You listening, Naib? Non-responsive to Paula. Whatever you wish for me to take from it, she says, it's not a direct response, nor is the quip about smuggling someone into the U.S. This judge is not happy with him. Maybe she'll hold him in contempt. Says, if you were removing domestic barriers, there would be no smuggling, right? And like Pam Bondi was like, yeah, we'll get you an airplane. Two misguided ships passing in the night, okay? It's not smuggling at all. So the judge says, well, we'll proceed to discovery. If I make a finding of contempt, we'll go from there. Now, I'm not saying one way or the other because I don't have the facts before me yet, but the transcript you gave me of the Oval Office interview doesn't answer those questions at all. And what have you done to secure his release and to ensure that his case is handled as it would have been had he not been improperly sent to El Salvador, which was not improper at all? What have you done? What are you planning to do? I've got nothing. Well, the DOJ says, well, we do think that that transcript was a very important step. They're like, Your Honor, we got a transcript. They didn't even write it, right? It's not even official. It's from rev.com. They found a website link on rev.com who transcribed it. Like, well, they had a meeting. They don't care. Statement from Bondi says, she said, we will facilitate the return. If Bukele sends him, she's going to send an airplane, Pam. Thanks for that. Judge says she's going to do it a conventional way. She says, all right, that's it. Now, there are no business hours, okay? We're following the legal rules here. Judge says, we're doing 2 weeks of intense discovery. Targeted. You're going to answer their questions. And if the gangbang lawyers go too far, you just tell me. If they're asking for too much information, you tell me and I'll call it fair. And if you don't abide by the rules and you don't give them what they're asking for, then they're going to tell me and I'll call it. Trump's DOJ, Drew, says, Your Honor, we just filed a declaration that we just read here from Mazzara. She says, well, first, we're not there. Okay, so hold off. Says, Abrego Garcia is not in the U.S. I ordered him to be here. So what do you want me to know? Is that answered in there? Your Honor, well, we gave you the update. So says Drew, we believe that that update satisfies what the Supreme Court told us to do. We are facilitating exactly within the meaning of the immigration law. We're doing it right now. We said we're happy to facilitate. If he wants to show up, we'll deport him again. No problem. Well, have you done it? No, Your Honor. If you haven't done it, then it's not relevant, she says, snapping at him. Your Honor, facilitate just means removing domestic barriers. That's all. It's in the statute. It's in the manual. We have a narrow interpretive dispute for which discovery is not necessary. You don't need to go into all this stuff. We're facilitating it according to the manual, and we're doing everything that the Supreme Court told us to do. Judge says, I disagree with you. Now, I'm prepared to issue an order which expands on my view on the meaning of the word facilitate. So I'll explain what it means. And we will operate within the parameters of that ruling. And it's consistent with what SCOTUS said and with what's common in immigration practice. And so your characterization, Trump, is not bound in fact. And I need facts here. Trump's DOJ says, Your Honor, facilitate only refers to domestic obstacles. It's in the manual. That's all we can do. Okay, immigration is a domestic issue. It's not foreign policy. That foreign policy stuff is not in the manual. She says it can be. Well, it can be case dependent, says the judge. It can be case specific. In this case specifically, SCOTUS has made clear. This is not in the ether out there. This is not a pure law situation. You need to ensure the case is handled the way it would have been handled according to the ICE manual. And it was handled appropriately, right? The invocation, the proclamation of alien enemies changed this guy's status, made his withholding no longer valid, and he got deported. It was handled appropriately. The Supreme Court just got a wrong brief from a poison pill DOJ attorney that was never valid. You have tools in your toolkit, she says. Going back several years, the government has taken positions on what facilitate means. You have done it in other cases. The question is, what are you going to do here? And so the facts need to be developed. The DOJ says, Your Honor, if you're going to issue an order that requires discovery, well, we would ask that you stay that order so that we can seek a timely appeal of this, because we're obviously going to do that. No, you don't get additional time. SCOTUS has already spoken. They already issued their ruling. There's nothing to appeal here. I want 2 weeks of targeted discovery, and you're going to answer these questions. DOJ says, well, Your Honor, maybe we can start with the interrogatories first. We can ask these questions, and then we can define the scope of this discovery, because we don't think that you're going to get into anything that you want to. Okay, we're going to call executive privilege and all sorts of protections that limit you, even, attorney-client protections and a bunch of other things that you're not going to get. Separation of powers arguments and tons of stuff. So if this court wants to issue an additional injunction, we want to understand what the court has in mind. Oh, she's getting mad. It's just not that difficult, okay? You may want to make it difficult because getting to the facts may not be favorable for you. Oh, discovery will give me a factual predicate for contempt to see if the defendants, Trump, are acting in good faith or not. And it will give you that opportunity. And we're going to do it in a targeted way. And we're not going to take a whole lot of time. DOJ says, Your Honor, well, we don't even think an Article 3 judge has the authority to require discovery of foreign sovereigns. You can't make El Salvador give us information, give you information, make us tell them to give us information. Well, nothing I've said here does that, okay? We're talking in generalities. You talking in generalities is simply delaying the process that we have to go through. And we're going to determine, have you done what my orders require? And if not, have you acted in good faith? Your Honor, we think you're going to have a difficult time getting this information because of separation of powers, and you don't have a right to come in. And just like we couldn't come into your courtroom and rummage through your files and all of those things, you can't come into our house and tell us how to do our job. You're not the president or the executive branch, so no. Judge says, well, I'm not ordering you to release him yet. I'm not there yet. Do it, Judge. Why not? Why aren't you there? Just do it. Like, if you think you have the power to do it, why are you letting this poor guy rot away in CCOT? An innocent man, an American Maryland man. Why not, Judge? You're not there yet? How come? Do it, because you won't. I will abide by the law, but we're not there yet. Yeah, that's right. We're not going to get there either. I'm just going to go back to what SCOTUS said is squarely within my prerogative to do, which is nothing, which is to respect the due deference of the executive branch. Trump's DOJ says, okay, well, I understand your position. We disagree because the question of what facilitate means is a pure question of law, and our interpretation is what we are elected to do, and it's not illegal. And so she says, I understand your position, and I'm prepared in a written order to reject it. Probably already wrote it. She published it. We'll read it. Now, at the end of the day, I'll issue the order. This is what the district courts are principally authorized to do. I'll be the referee, she says. I'll issue a certain number of interrogatories, which are questions to each side. I'll give the plaintiffs opportunity to take depositions of the defendants, okay, which is going to be just amazing. If you have objections, put them with specificity rules required. You engage in good faith meet and confers. And I'll explain how you get expedited review of these disputes. I'll explain how through letters, how we'll do this. Then I'll hold a conference to decide. We'll get through this in 2 weeks. And if we don't, that'll be an issue in itself. We're going to have all of these depositions completed by 4/23. So they're going to haul people in. DOJ says, okay, well, we understand the court's position. Judge says, and by the way, Mr. Cerna, there are 3 additional affiants, all of which told me based on personal knowledge, certain facts. Well, Your Honor, we're not prepared to make objections at this time. One is a GC of ICE. Are you talking about privilege? Yes. Okay, well then lay that out as soon as possible. You already put them up as an affiant in a prior document. Well, I don't know their availability. Like if you're going to want us to bring all these people in, well, they can cancel their vacation. Cancel it. I expect all hands on deck. It won't be a convenience issue, okay? Maybe depositions could be in a courthouse, so I can call balls and strikes. Your Honor, we don't think discovery is appropriate because this is a legal dispute. It's about what the word facilitate means. It's not a fact-finding endeavor. So we'd like you to flesh out what facilitate means so we can just operate that way. Well, I hear you. You are going to have some written guidance and your objection is preserved. How about you, gangbang ACL Kilmar lawyers? We agree with your plan, Judge. This is great. We're getting everything we want. No further statement. Judge says, okay, 15 interrogatories, 15 requests for productions. If you don't need 15, you don't proud 15. Keep it targeted, keep it tight. 4 depositions apiece, up to 2 additional. Now, my target is that at the conclusion, the Kilmar lawyers will supplement their motion, and then you'll respond by 4/28, and defendants will respond by 4/30. Now, I'm going to put it all in writing, and the hearing is concluded. Judge Zinnes also came out and issued her order. Says, pending before this court is Kilmar Garcia's motion for expedited discovery. They seek discovery of any terms of agreement or anything that the U.S. government has with CCOT. Okay, so like a contract for the illegals. They also want discovery about his current physical location, custodial status, what steps, if any, the government has taken to facilitate his return. Trump opposes this request because it's not consistent with the word facilitating, which is what the Supreme Court ordered. And there are also other constitutional infirmities that exist, separation of powers and more. Now, for the following reasons, Judge Zinnes grants the motion for discovery. She tells us upon a showing of good cause, she can make this order and writes, it is undisputed that Abrego Garcia is entitled to injunctive relief for reasons previously discussed and affirmed without exception, which I think that's inaccurate. Okay, she's just saying that the Supreme Court is saying that there is no exception. There is an exception. They wrote it in there. It's with due deference to the executive branch. branch. You don't get everything you want. If you got everything you wanted, the Supreme Court would have said they would have ordered him out. They didn't. So it's just ridiculous. Now, as to the scope of the relief, there you go. The Supreme Court unanimously affirmed that the order properly requires the government to facilitate the release from custody. What does that word mean? To ensure that his case is handled as it would have been had he not been improperly sent to El Salvador. But guess what? He was not improperly sent to El Salvador. That's their position. To that end, the Supreme Court forewarned the government, writes Zenas, that they should be prepared to share what it can concerning the steps that it has taken. Now, this court, in turn, ordered no more than what the Supreme Court endorsed, that they take all steps to facilitate the return as soon as possible. And within that remedy is the release from custody. So to advance that, she demanded the 3 questions be answered. Where is he? What are you doing to get him out? What additional steps will you do until he's out? And that information is wholly consistent with ascertaining what you have done to facilitate his release. Now, notably, she's going to explain facilitate. It means to make the occurrence of something easier, to render less difficult. She went to Black's Law Dictionary. Merriam-Webster writes to make easier or less difficult, to free from difficulty or impediment. She goes to Oxford and more. So she says there, it's easy. So therefore, you remain obligated at a minimum to take steps available to them toward aiding, assisting, and making easier his release from custody in El Salvador and resuming his status quo ante. Now, they've already done that. If he shows up, they'll deport him again. That's how they'll facilitate him into America. That's the step that they take at minimum. But the record reflects they've done nothing at all. No, it doesn't actually. They just submitted it yesterday. Now, it's not to your liking that we'll just rearrest him and deport him again, but that's how we're going to facilitate it. Instead, they obliquely suggest that facilitate is limited to taking all of the domestic obstacles out of the way. But the fallacy is twofold. They say, well, first, in the immigration context, writes the judge, facilitating the return of those wrongly deported can and has included more extensive governmental efforts endorsed in prior precedent and Homeland publications, but he wasn't erroneously deported. The Alien Enemies Act overrides that lower level district judge's order of withholding of removal. Thus, the court cannot credit facilitating the ordered relief is as limited as Trump suggests. And secondly, and more fundamentally, Trump appears to have done nothing to aid in the release. To ensure that his case is handled as it would have been, they just said they would have handled it. If he was not returned to El Salvador, they would have just picked him up and returned him to El Salvador again. Thus, the attempt to skirt this issue by redefining facilitate runs contrary to law and logic. I hope she explains. She didn't. Turning to the factors supporting expedited discovery, she says, first, my injunction is active and enforceable, and the discovery is relatively narrow in scope, and we need an immediate evidentiary hearing, and so the court will permit discovery as set forth below, saying it's necessary. They're refusing to disclose what they're doing and to return him to the status quo, and it's not burdensome on the government. The request for discovery is timely, and he is inexplicably detained in CCOT. It's not inexplicable. It's totally explained. We've explained it 15 times here, and the judge has gotten the explanation via declaration. 6, discovery must proceed without delay. He's entitled to due protections that have been denied him. He got them. He had a full trial and an appeal, and to be free from risk of grave injury resulting from his detention in CCOTS. 7th, the absence of a dismissal motion is of no moment, and so the court will permit expedited discovery. So here are the details about his physical location, what steps they've taken to return him, what they will do to facilitate his return, okay, and facilitate in both of those. So we got deadlines, Wednesday, April 16th, Wednesday, April 16th, another one Wednesday, April 23rd. So notice the depositions for all these people, everybody who submitted a declaration, Cerna, Katz, Kazak, Mazzara, and they may get 15 interrogatories against Trump and 15 requests for productions against Trump. And then they shall serve their answers back on them no later than Monday, April 21st. So the floodgates are going to open. These are all orders. Trump is going to, I think, dig in and not give them much of anything. To streamline review of these objections, the court will file a separate letter about disputes. At the conclusion of this, you shall supplement what you found and ask for more relief. And if Trump fails to engage in good faith, you can seek sanctions on Trump. So ordered by Judge Paula Zenas, rhymes with, and you can hear how angry she is. So that order came down. We'll see what Trump says. I'm sure there will be immediate appeals on all of this, and we'll just wait for those to drop. But we went through, we saw what it looked like outside there. Here was Pam Bondi talking about this on with Jesse Waters.
Jesse, you know, when you're listening to all these liberal reporters, they keep calling him a Maryland man. He's not a Maryland man. He's part of a foreign terrorist organization. He's a member of MS-13, who, as you laid out in your monologue, came to this country and committed just gang acts. He was caught, and he was 2 judges, an immigration judge and an appellate judge, ruled that he was an MS-13 member, as well as ICE's testimony. Yet his attorneys are saying he's not affiliated with the gang. They're wrong, and he has no right to be there, but for an extra step in paperwork, just like you said, he would go right back to El Salvador, which is his home country, where he belongs. And President Bukele does not want to give him back to the United States, nor do we want him back.
Right, so that's it.
All right, so that's Pam Bondi. We also had Caroline Levitt explaining how all of this works to the folks in the media. This was clipped over via the Vigilant Fox on X. Great follow. Make sure you're giving them a follow. Here is what Caroline Levitt had to say when asked about this during today's press briefing.
I also want to thank your press office for releasing that information that you cited up there regarding the ICE arrests over the last couple of days. And I have them right here, but what I might ask is, why not release the same information for those who were deported to El Salvador?
Well, first of all, that information was released by the Department of Homeland Security. The individuals on the flights to El Salvador are foreign terrorists, and those are counterterrorism operations. They are much different than the arrests and final order of removals that you see on a day-to-day basis that law enforcement agents are conducting around the country.
That information was not, to that detail, was not released by DHS, though.
I just told you the reason. It was a counterterrorism operation, a deportation of foreign terrorists, not illegal criminals who have been convicted of heinous crimes living in our American communities. Two different things. Foreign terrorist, illegal immigrant criminal, two different things, two different definitions. You should look them up.
Yeah, maybe read a book for once, dum-dum. Look up the definition and you'll understand there's a distinction. When Papusa Boy came in, he was flying under the radar. Actually, not really, right? He was held non-bondable until Joe Biden and others came in and changed everything. And then a lot of these types of people got released. But I think his withholding, I forget when that was. That might have been under the Trump administration. But my point is, the withholding of removal was for a situation that, first of all, is no longer in existence in El Salvador because Papusa business is no longer under attack by that gang. But MS-13 has now been declared what they are. We're actually applying the appropriate labels to what has been happening to our country. And that changes what is allowable under the law. And an illegal alien who is in our country illegally went back home to his home country. And we're hopeful the media looks it up. There's a difference between a Papusa boy and an MS-13 member, and he's gone accordingly.